Petroleum, Exploration and Production, Act, 2016 Act 919. Scope of the Act. Section 1. This Act applies to petroleum activities within the jurisdiction of the Republic of Ghana, including activities in, under, and upon its territory all and, inland waters, territorial sea, exclusive economic zone and its continental shelf. Object of the Act. Section 2. The object of the Act is to provide for and ensure safe, secure, sustainable, and efficient petroleum activities in order to achieve optimal long-term petroleum resource exploitation and utilization for the benefit and welfare of the people of Ghana. Title to Petroleum. Section 3. Petroleum existing in its natural state in, under, or upon any land in Ghana, rivers, streams, water courses throughout Ghana, the exclusive economic zone and any area covered by the territorial sea or continental shelf, is the property of the Republic of Ghana and is vested in the President on behalf of and in trust for the people of Ghana. Management of petroleum resources. Section 4. The management of petroleum resources by the Republic of Ghana shall be conducted in accordance with the principles of good governance, including transparency and accountability and the object of this Act. Petroleum Agreement. Section 10. 1. A body corporate shall not, unless otherwise provided in this Act, engage in the exploration, development and production of petroleum except in accordance with the terms of a petroleum agreement entered into between that body corporate, the Republic of Ghana and the corporation. 2. A contractor shall, subject to the provisions of this Act, carry out petroleum activities in the contract area as provided in the Petroleum Agreement. 3. A petroleum agreement shall only be entered into after an open, transparent, and competitive public tender process. 4. Despite subsection 3, the minister may on stated reasons decide not to enter into a petroleum agreement after the tender process as prescribed. 5. Where all or part of the area offered for tender in a public tender process has not become the subject of a petroleum agreement, but the minister determines that it is in the public interest for that area to be subjected to a petroleum agreement, the minister may initiate direct negotiations with a qualified body corporate for a petroleum agreement. 6. The minister shall publish an invitation to tender or an invitation for direct negotiations in the Gazette and in at least 2 state-owned daily newspapers and may publish the invitation in any other medium of public communication. 7. A body corporate who wishes to submit a bid or participate in negotiations shall submit an expression of interest to the minister, as prescribed. 8. Where the minister receives more than one expression of interest, a tender process in accordance with subsection 3 it shall be undertaken. 9. Despite subsection 3, the minister may, in consultation with the Commission, determine that a petroleum agreement may be entered into by direct negotiations without public tender, where direct negotiations represent the most efficient manner to achieve optimal exploration, development, and defined area production of petroleum resources. In a 10. The Republic may enter into a petroleum agreement with a body corporate that has the requisite technical competence and financial capacity to fulfill the obligations of the petroleum agreement and other requirements as prescribed. 11. The minister may require a consortium as a condition for entering into a petroleum agreement. 12. The minister shall represent the Republic of Ghana in the negotiation of the terms of a petroleum agreement and shall enter into a petroleum agreement on behalf of the Republic. 13. A petroleum agreement entered into by the minister shall not be effective if it is not ratified by Parliament in accordance with Article 268 of the Constitution. 14. A petroleum agreement shall contain a term that the corporation shall a. Hold an initial participating carried interest of at least 15% for exploration and development, and b. Have the option to acquire an additional participating interest as determined in the petroleum agreement which 1. May be exercised within a specified period of time following the declaration of commercial discovery, and 2. Shall be a paying interest in respect of cost incurred in the conduct of petroleum activities. other than exploration cost. 15. Any borrowing exceeding the SEDI equivalent of 30 million United States dollars for the purpose of exploration, development, and production shall be approved by Parliament and shall be in consonance with the Petroleum Revenue Management Act, 2011, Act 815. Operator. Section 13. 1. The Minister shall approve the operator before the execution of a petroleum agreement. Under Section 10. 2. The Minister shall appoint an operator where the parties cannot agree on the choice of an operator. 3. An operator shall be a contractor, the corporation, a body corporate owned by the corporation, or a body corporate owned by the contractor and the corporation. 4. The Minister may approve a change of an operator upon the request of a contractor or the corporation. 5. The Minister shall, in consultation with the Commission and the corporation, change an operator in circumstances where that operator ceases to meet material requirements of this Act. Other applicable enactments and a petroleum agreement. Duration. Section 14. 1. A petroleum agreement shall, subject to subsection 2, be for a period of not more than 25 years. 2. Where production from a field is projected to extend beyond the original term of the petroleum agreement, the Minister may a. Approve an extension of the petroleum agreement on the terms agreed by the parties, or b. Execute a new petroleum agreement by direct negotiations in accordance with Section 10, to ensure optimal production from the field. 3. The extension of a petroleum agreement or the execution of a new petroleum agreement is subject to ratification by Parliament. Change of ownership. Section 15. A contractor or subcontractor shall not transfer a share of that contractor's or subcontractor's incorporated company in the Republic to a third party or affiliate without the written approval of a. The Minister, in the case of a contractor, or b. The Commission, in the case of a subcontractor, if the effect of the transfer would be to c. Give the third party or affiliate control of the company, or d. Enable the third party or affiliate to take over the interest of a shareholder who owns 5% or more of the shares of the company. Assignment. Section 16. A contractor or a licensee shall not without the written approval of the Minister, directly or indirectly assign the interest of the contractor under a petroleum agreement, whether in whole or in part, to a third party or an affiliate. Subcontracting. Section 17. 1. A contractor or subcontractor shall not enter into a petroleum subcontract without the written approval of the Commission. 2. The Commission shall approve the threshold for the value of petroleum subcontracts as prescribed. 3. A subcontractor shall register with the Commission as prescribed. 4. A contractor shall not award a petroleum subcontract to a company that is not registered with the Commission. 5. A contractor shall not enter into an agreement with an affiliate for the 11 E's of a petroleum facility to be used for petroleum activities without the written approval of the Commission. 6. A person shall not without the written approval of the Commission directly or indirectly assign, whether in whole or in part, a right or obligation under a subcontract to a third person or an affiliate. Preemption. Section 18. 1. Where a contractor enters into an agreement to dispose of all or part of the interest of that contractor directly or indirectly under a petroleum agreement, the corporation shall have a pre-emption right to acquire the interest on the same terms as agreed with the potential buyer. 2. Where the consideration agreed is not in monetary terms, the corporation may pay the corresponding monetary value of that consideration. 3. Where a contractor has entered into an agreement to dispose of all or part of the interest of that contractor under a petroleum agreement, the contractor shall notify the Minister, the Commission, and the corporation immediately of the consideration and other terms agreed. 4. The corporation shall notify the contractor of the election of the corporation to exercise the preemption right within 90 days of the receipt of the notification. Review of terms and conditions. Section 20. 1. The terms of a petroleum agreement may be reviewed by the parties to the agreement where there is a material change in the circumstances that prevailed at a. The time the agreement was executed, or b. The last review of the agreement. 2. A petroleum agreement that is reviewed under subsection 1 is subject to ratification by Parliament in accordance with Article 268 of the Constitution, if the review results in material change. Exploration period and extension. Section 21. 1. A petroleum agreement shall contain as a term of the agreement, a provision that specifies that the exploration period is, subject to subsection 5, not more than 7 years from the effective date of the agreement. 2. The exploration period shall consist of working periods, comprising an initial exploration period and up to 3 extension periods as provided for in the petroleum agreement, within the total exploration period. 3. On the fulfillment of the work and expenditure obligations stipulated in a petroleum agreement. For a relevant working period under subsection 2, the contractor may enter into the subsequent working period and shall exercise that option by written notification to the Commission before the expiration of the relevant working period. 4. The Commission may extend each working period on application by the contractor, and the extension shall be granted on the condition that the contractor has carried out substantial part of the work program stipulated in the petroleum agreement in a prudent manner and to the satisfaction of the Commission. 5. The Minister in consultation with the Commission may extend the exploration period beyond 7 years from the effective date of the petroleum agreement. A. Where a discovery of petroleum is made in the last year of the exploration period, and an extension is necessary to enable a determination to be made of whether the discovery is a commercial discovery, or B. In exceptional situations as prescribed. 6. Or an extension in subsection 5a shall A. Only apply to the reduced area encompassing the geological structure in which the discovery is located, and B. Be limited to the time period necessary for the determination of whether the discovery is a commercial discovery. 7. Where a contractor before the expiration of the exploration period has not submitted to the Minister a declaration that the petroleum discovered in a contract area is a commercial discovery, the petroleum agreement shall terminate. Relinquishment of contract area. Section 22. 1. A contractor may submit to the Commission a proposal to relinquish a contract area or part of a contract area. 2. The Commission may approve the proposal in accordance with prescribed conditions. Coordination of petroleum activities and unitization. Section 34. 1. Where an accumulation of petroleum extends beyond the boundaries of one contract area into one or more other contract areas, the Minister in consultation with the Commission may, for the purpose of ensuring optimum recovery of petroleum from the accumulation of petroleum, direct the relevant contractors to enter into an agreement to develop and produce the accumulation of petroleum as a single unit. 2. The agreement shall be entered into within a period specified by the Minister and shall be submitted to the Minister for approval. 3. Where 2 or more accumulations of petroleum are in proximity to one another but are A. In different contract areas, or B. In one contract area and an area not covered by a petroleum agreement, the Minister may require the accumulations of petroleum to be developed and produced in a coordinated manner in order to ensure efficient petroleum activities. 4. Where an accumulation of petroleum extends beyond the boundaries of a contract area into an area not covered by a petroleum agreement or an authorization under Section 11(1), the Minister may authorize the corporation to enter into a contract for the development and production of the accumulation of petroleum, and require the accumulation of petroleum to be developed as a single unit. 5. The Minister may stipulate conditions and make appropriate directions to the corporation and the contractor as prescribed for the unity's development, and such conditions, if significantly different from the conditions of the adjoining contract area, shall be ratified by Parliament. Cross-border cooperation and unitization. Section 35. The Republic may, where an accumulation of petroleum extends onto the land or the continental shelf of another country, seek to reach agreement with that other country on the most efficient coordination of petroleum activities in connection with accumulation of petroleum as well as the apportionment of the accumulation of petroleum. Third-party use of production facilities. Section 36. 1. The Commission may direct that facilities which are owned by a contractor or the corporation may be used a. by others if warranted by considerations for efficient operation and resource management, or b. for the benefit of society where the use would not unreasonably interfere with the usage, requirements of the contractor or the corporation or of any person who has already been granted the right of use. 2. An agreement on the use of facilities shall be submitted to the Commission for approval and the Commission may, as a condition for approval, modify the tariffs and other conditions agreed between the parties, having due regard to resource management considerations and a reasonable return on investment for the owner. 3. The Commission may, where an agreement for use is not reached within a reasonable period of time, stipulate the tariffs and other conditions for use, having due regard to resource management considerations and a reasonable return on investment for the owner. 4. Where required for resource management considerations, the Commission may alter the conditions of a previously approved agreement for third-party use to ensure the implementation or continuation of projects. 5. In stipulating new conditions, the Commission shall have due regard to resource management considerations and a reasonable return on investment for the owner. 6. The rights and obligations of the contractor under this section apply to the corporation where it undertakes petroleum activities under Section 11(1). Third-party use of transportation, treatment, and storage facilities. Section 42. 1. An owner and operator of a facility for the transportation, treatment, or storage of petroleum shall grant third-party access to the facility on fair, transparent, and non-discriminatory terms. 2. The access shall not be to the detriment of the needs of the owner, operator, or other users who have already been granted a right of use. 3. If the throughput capacity of the facility is insufficient to handle and transport the total production entitlement of all users, the owners of the facility shall have a preferential right to the available capacity in proportion to the ownership share. 4. The remaining available capacity shall be shared between the users in proportion to the total production entitlement of each user which would otherwise be available for transportation. 5. The owner or operator of a petroleum pipeline may charge a transportation tariff for the use of the pipeline by other persons. 6. Unless otherwise determined by the Commission. A. The transportation tariff shall cover the cost incurred by the owner of the pipeline in constructing, financing, operating and maintaining the pipeline and related facilities, including a reasonable rate of return on the investment, taking into account the risks assumed by the owner. And b. Each user including the owner of the pipeline, shall pay a transportation tariff calculated in relation to the share of the petroleum transported. 7. A person is not entitled to the use of a transportation, treatment, or storage facility unless that person has entered into an agreement with the owner or operator of the facility. 8. The parties shall submit an agreement on the use of transportation, treatment, and storage facilities to the Commission for approval. 9. The Commission in consultation with the Minister may, as a condition for approval, change the tariffs and other conditions agreed between the parties, having due regard to resource management considerations while allowing the owner reasonable returns, taking into account investment and risks. 10. Where an agreement for use is not reached within a reasonable period of time, the Commission in consultation with the Minister may determine the tariffs or other conditions for the use, having regard to resource management considerations while allowing the owner reasonable returns taking into account investment and risks. 11. Where required for resource management considerations, the Commission in consultation with the Minister may alter the conditions of an approved agreement in order to ensure implementation or extension of projects. 12. The Commission shall, in altering the conditions of an approved agreement, have due regard to resource management consideration, investments, and risks. Ownership of petroleum data. Section 52. 1. Data and information obtained by a licensee, contractor, subcontractor, or the corporation as a result of petroleum activities and the geological, geophysical, technical, financial, and economic reports, studies, interpretations, and analyses prepared by or on behalf of a licensee, a contractor, subcontractor, or the corporation in connection with petroleum activities shall be the property of the Republic. 2. Subject to Section 53(5), a licensee, contractor or subcontractor may, for the duration of a license or petroleum agreement, use the data and information under subsection 1. 3. The licensee, contractor, subcontractor, or corporation shall provide to the Commission data and information as well as the reports, studies, interpretations, and analysis under subsection 1. 4. The Commission may permit a licensee, contractor, subcontractor, or the corporation to market the right of use to geological, geophysical, and technical data, reports, studies, and interpretations on terms to be agreed. 5. The Commission may provide any data or information to the corporation for its use. Liabilities. Section 59. 1. Subject to subsection 2. Licensee parties or contractor parties, who jointly hold a petroleum agreement or license are jointly and severally responsible to the Republic for the financial and other obligations and liabilities arising out of the petroleum activities. 2. A contractor and a licensee are not jointly and severally responsible for payment of taxes, royalties in cash, and additional oil entitlement. 3. A licensee, contractor, or subcontractor shall keep the repo and the corporation indemnified against claims arising from the operations of the licensee, contractor, or subcontractor brought by a third party. 4. Where third-party liability is incurred by a person who undertakes a task for a licensee, contractor, subcontractor, or the corporation, the licensee, contractor, subcontractor, or the corporation is liable for damages to the same extent as, and jointly and severally with the person undertaking the task and, if applicable, the employer of the person. Employment and training of Ghanaian citizens. Section 60. 1. A licensee, contractor, subcontractor, or the corporation shall ensure that Ghanaian citizens who have the requisite expertise or qualifications in various levels of activities are employed in accordance with applicable enactments, the terms and conditions of the license, petroleum agreement or petroleum subcontract. 2. A person carrying out petroleum activities shall be required to employ Ghanaian citizens in categories and functions as prescribed. 3. Subject to subsection 2. A person carrying out petroleum activities shall not engage in discriminatory practices on grounds of race, tribe, nationality, or gender in the conditions of service provided for personnel. 4. A person carrying out petroleum activities shall, in consultation with the Commission, prepare and implement plans and programs to train citizens in all aspects of petroleum activities in accordance with the regulations and the terms of the license, petroleum agreement, or petroleum subcontract. Use of Ghanaian goods and services. Section 61. 1. A licensee, contractor, subcontractor, or any other allied entity shall a. Acquire materials, equipment, machinery, and consumer goods which be produced or provided for in the country by an indigenous Ghanaian company and which 1. Are of the same or similar quality as foreign materials, equipment, machinery, and consumer goods, and 2. Are available for sale and delivery in due time at prices which are not more than 10% higher than the imported items, including transportation and insurance costs and customs charges. Do. B. Contract local service providers to the extent to which the services they provide are similar to those available on the international market and their prices, when subject to the same tax charges, are no more than 10% higher than the prices charged by foreign contractors for similar services. 2. This section applies to the corporation where it undertakes petroleum activities under Section 11(1). Technology transfer. Section 62. 1. For the purposes of technology transfer, the Commission shall encourage and facilitate the formation of joint ventures, partnership, and the development of licensing agreements amongst indigenous Ghanaian companies, foreign contractors, and service or supply companies interested in the petroleum industry where applicable. 2. This section shall not be interpreted to disable the licensee, contractor, subcontractor, or the corporation from protecting its competitive position in the petroleum industry. Local content plan. Section 63. 1. A licensee, contractor or subcontractor shall prepare and implement a local content plan, as prescribed. 2. The local content plan shall be submitted to the Commission for approval. 3. The local content plan includes a plan for fulfilling the applicable Ghanaian content requirements with respect to the provision of goods and services. B. A plan for the transfer to the corporation of technological know-how and skills related to petroleum activities, and C. A detailed annual recruitment and training program. 4. The licensee, contractor or subcontractor shall submit an annual report on the local content plan, describing the initiatives taken in the preceding year and their results. Incorporation of local company. Section 70. 1. Except for licensees and subcontractors that may by applicable enactments be exempted from the requirement of this subsection, a contractor, subcontractor or licensee shall a. Incorporate in this country under the provisions of the Companies Act, 1963, Act 179, a. Company to carry out solely petroleum activities in respect of licenses, petroleum agreements or petroleum subcontracts, and that company shall be 1. The legal entity granted a license, or 2. The signatory to the petroleum agreement or the petroleum subcontract. B. Maintain an office in this country from which the petroleum activities shall be managed. C. Have in charge of the office a representative with full authority to act and to enter into binding commitments on behalf of the licensee, contractor or subcontractor, and D. In respect of the petroleum activities, open and maintain an account with a bank in this country. 2. The minister may stipulate specific requirements in respect of the structure and the capital of the company incorporated in this country. Domestic supply requirement. Section 71. 1. Subject to subsection 5, a contractor may export from the Republic petroleum which the contractor is entitled to export under the terms of a petroleum agreement. 2. A contractor shall sell to the Republic at the prevailing market price as prescribed, for the same period a percentage of the petroleum to which the contractor is entitled, to meet domestic supply requirements as determined by the minister. 3. Domestic supply requirement is the difference between the total petroleum entitlements of the Republic and the corporation and the total volume of petroleum in barrels of oil or MMSCFD of gas, equivalent of petroleum products required to meet the demand in the country. 4. The volume of petroleum to be supplied by the contractor shall be calculated on the basis of the pro rata share of the petroleum to which the contractor is entitled, but each party's obligation to supply petroleum for domestic supply requirement shall not exceed the total of the entitlement of that party under the petroleum agreement. 5. In the event of war or other emergency affecting energy supplies, the minister may require a contractor or the corporation to supply all or part of the quantity of petroleum produced at the prevailing market price to the Republic or any agency of the Republic. Interference with lawful activities, compensation and access to land. Section 72. 1. Where the conduct of petroleum activities is likely to affect any lawful economic or social interest or activity of the inhabitant of an area, the corporation, or in the case of a licensee, the Commission shall negotiate the appropriate permission required from the relevant authorities and interested persons, and the licensee, the contractor, or the corporation shall pay the agreed compensation to the interested persons. 2. Where there is hindrance to the acquisition of property, the property may be acquired for the corporation under the State Lands Act, 1962, Act 125, and the corporation shall bear the cost. Safety requirements and standards. Section 73. 1. Petroleum activities shall be conducted in a manner that ensures that a high level of safety is achieved, maintained, and further developed in accordance with technological developments, best international practice and applicable enactments relating to health, safety, and labor. 2. A plan and related documents for implementation of safety measures of petroleum activities shall be submitted to the Commission before the commencement of the relevant petroleum activities. 3. The plans and documents shall be updated as and when required. Safety precautions. Section 74. A licensee, contractor, subcontractor and the corporation shall a. Identify the hazard and evaluate the risks associated with any work performed in the course of petroleum activities which constitute a hazard to the health and safety 1. Of persons employed for purposes of that work, and 2. Of persons otherwise present at or in the vicinity of the facility, and the steps that need to be taken to comply with the provisions of this Act and regulations. B. Ensure the safety of the persons referred to in paragraph A, and prevent their exposure to the hazard or where prevention is not reasonably practicable, minimize their exposure, and C. Ensure that the persons referred to in paragraph A are duly informed of the safety precautions. Emergency preparedness. Section 75. A person conducting petroleum activities shall at all times a. Maintain efficient emergency preparedness to prevent, control, handle and minimize accidents and emergencies which may lead to loss of life or personal injury, pollution, or major damage to property including fire, oil spills, gas leakages, blowouts, accidents or other emergency situations, and b. Ensure that necessary measures are taken to prevent or reduce harmful effects, including the measures required to return the environment to the condition it was before the accident occurred. Emergency preparedness against deliberate attacks. Section 76. A licensee, contractor, subcontractor or the corporation shall implement and maintain preventive security measures, including control of personnel and goods, to protect their petroleum facilities and wells from deliberate attacks and shall have contingency plans to deal with those attacks. Safety zones. Section 77. 1. Every petroleum facility and well shall be surrounded by a safety zone unless otherwise determined by the Commission. 2. The Commission shall, in consultation with relevant authorities, determine the delimitation of the safety zone. 3. Unauthorized vessels, vehicles, fishing gear or other object or craft shall not enter a safety zone established under this section. 4. The Commission may permit lawful activities to take place in the zone or in parts of the zone, if the activities can be conducted without threatening safety or interfering with the exercise of the petroleum activities. 5. The Commission may determine and establish the boundaries of the safety zone as prescribed before the placement of petroleum facilities. 6. In the event of accidents and emergencies, the Commission may establish or extend a safety zone under subsection 5. 7. The Commission may decide that a safety zone shall be established for abandoned wells, abandoned or decommissioned facilities or parts of those facilities. 8. The Minister may, with the advice of the Commission and any other relevant agency, determine that a safety zone should extend across the international boundary with another state and may initiate the appropriate processes for implementation. 9. The Minister and the Commission shall consult the other relevant authorities and agencies for the purpose of establishing and managing a safety zone under this section. Suspension of petroleum activities. Section 78. 1. Where an accident or emergency may lead to or has resulted in loss of life or personal injury, pollution or major damage to property, the licensee, contractor, subcontractor or the corporation shall a. To the extent necessary, suspend the petroleum activities for as long as required by the Petroleum Operating Standard under Section 50, and b. Immediately but not later than 48 hours, inform the Minister and the Commission of the suspension. 2. In the event of emergencies or accidents under subsection 1, the Minister may, acting on the advice of the Commission, a. Direct that petroleum activities be suspended to the extent necessary if required in the public or national interest, or b. Impose particular conditions to allow continuation of the activities. Measures to ensure safety. Section 79. 1. Where a licensee, contractor, subcontractor or the corporation fails to conduct the activities in a safe manner in accordance with applicable enactments and best international practice, the Commission may take necessary measures to ensure safety and may recover the costs and expenses of doing so from the licensee, contractor, subcontractor or the corporation. 2. The Commission may take measures under subsection 1 only after giving the contractor, contractor, licensee or the corporation reasonable notice. Qualifications. Section 80. The licensee, contractor, subcontractor and the corporation shall ensure that a person engaged in petroleum activities possesses the requisite qualifications and competence to perform the functions in a prudent manner. Environmental principles and protection. Section 81. 1. A person who undertakes petroleum activities shall take into account and give effect to the environmental principles prescribed in the Environmental Protection Agency Act, 1994, Act 490. Subsidiary legislation made under that Act and any other applicable enactments. 2. A licensee, contractor, subcontractor or the corporation undertaking petroleum activities shall a. Take necessary measures to ensure that petroleum activities are conducted in a safe and secure manner, free from accidents, waste dumping and pollution. B. Establish and implement effective and safe systems for 1. The disposal and treatment of waste, and 2. The prevention of pollution resulting from petroleum activities, in accordance with applicable enactments and best petroleum industry practice, and C. Establish a system to track the source, transport and destination of potential hazardous waste from petroleum activities. Liability for pollution damage. Section 83. 1. A licensee, contractor or the corporation carrying out petroleum activities under Section 11(1) is strictly liable for any pollution damage caused by or resulting from the petroleum activities. 2. Where several licensees or contractor parties are involved in the petroleum activities, the parties are jointly and severally liable for any pollution damage caused by or resulting from the petroleum activities. 3. Where pollution damage occurs as a result of petroleum activities conducted without proper authorization. A. The person who conducted the petroleum activity, and B. Any other person who took part in the petroleum activity and who knew or should have known that the activity was conducted without proper authorization are strictly liable for the damage. 4. The licensee, contractor, subcontractor or the corporation shall institute the necessary measures to remedy any pollution caused. 5. Where the remedial measures are not taken within the time limit set by the Commission or the Minister, a third party may be engaged for the performance of the measures, and the licensee, contractor, subcontractor or the corporation shall be liable for any related cost. Compensation for pollution damage. Section 84. 1. Where there are several contractor parties under a petroleum agreement or several licensees under one license, a claim for compensation for pollution damage shall initially be made against the operator. 2. Where there are several licensees or contractor parties and one of them fails to pay the share of the compensation, the unpaid amount shall be paid by the other licensees or contractor parties in proportion to their participating interest. 3. Where an event of force majeure results in pollution damage, the Minister shall, on the advice of the Commission, assess the damage taking into account A. The scope of the activity. B. The measures taken to avoid or mitigate the effect of the force majeure event. C. The situation of the party that has sustained the damage as a result of the force majeure event, and D. The insurance opportunities for each party. 4. On the basis of the assessment, the Minister shall require the person liable for the pollution damage to pay compensation. Payment of royalties. Section 85. 1. The contractor shall pay to the Republic royalty in respect of gross volume of petroleum produced and saved. Annual fee in respect of acreage. Section 86. 1. A contractor shall pay the Republic annual acreage fees. 2. The Minister shall prescribe the amount to be paid, except that where the amount is not prescribed, the annual acreage fees shall be as provided in accordance with the terms of a petroleum agreement in respect of the area to which the agreement relates. 3. This section applies to the corporation where it undertakes petroleum activities under Section 11.1. Tax. Section 87. A licensee, contractor, subcontractor, and a corporation shall pay taxes, including petroleum, income tax and capital gains tax in accordance with applicable enactments. Bonus payments. Section 88. A contractor shall pay bonus to the Republic as may be prescribed, except that where the type and quantum of the bonus payable is not prescribed, the bonus shall be paid as otherwise provided, in accordance with the terms of a petroleum agreement in respect of the area to which the agreement relates. Additional oil entitlement. Section 89. The Republic is entitled to a portion of a contractor's share of petroleum produced from each field on the basis of the after-tax inflation-adjusted rate of return that the contractor achieved with respect to each field.